We need to analyze a pivotal development taking place within the United States legal system, specifically regarding a Supreme Court hearing that carries the potential to fundamentally restructure the American federal government. While much of the news cycle focuses on daily political rhetoric, the arguments presented in the case of Trump versus Slaughter touch upon the very architecture of executive power. This is not merely about one personnel decision. It is about whether the concept of an independent agency can legally exist under the U.S. Constitution, or if every single federal employee must be directly subject to the will of the chief executive. To understand the gravity of this situation, we first need to look at the specific event that triggered this legal battle. The controversy centers on the firing of Rebecca Kelly Slaughter, a commissioner at the Federal Trade Commission, or FTC. Under the standard operation of the U.S. government, commissioners at agencies like the FTC serve fixed terms. These terms are designed to overlap different presidential administrations, specifically to ensure stability. Rebecca Kelly Slaughter was serving a term that was legally scheduled to continue until 2024. However, in March 2025, Donald Trump removed her from her position. Now, this is where the legal nuance becomes extremely important. In the corporate world, or even in standard political appointments like cabinet secretaries, a firing can happen for almost any reason. But for independent agencies, the law has historically required what is known as cause. Usually, cause is defined strictly as inefficiency, neglect of duty, or malfeasance in office. Essentially, you have to be bad at your job, lazy, or corrupt to get fired. However, the justification provided for removing Slaughter was none of those things. The stated reason was a lack of agenda alignment. This is a critical phrase to analyze. Lack of agenda alignment essentially means she was doing her job as an independent regulator, but her decisions did not mirror the political desires of Donald Trump. She was not accused of misconduct, she was accused of independence. By firing her for this reason, Donald Trump is effectively challenging a legal framework that has stood for nearly a century. This brings us to the core legal concept at stake here, a precedent known as Humphrey's executor. To fully grasp why the Supreme Court's decision is so heavily anticipated, we have to go back to 1935. In that year, the Supreme Court ruled that President Franklin Roosevelt could not fire a Federal Trade Commission member simply because he wanted someone who agreed with his political views. The court established that Congress has the authority to create agencies that are quasi-legislative or quasi-judicial, meaning they need to operate outside the immediate political pressure of the White House. The logic behind Humphrey's executor is that certain sectors of the government, specifically those dealing with financial markets, labor rights, and consumer protection, should be managed by experts based on facts and law, not by loyalists based on political expediency. For 90 years, this has been the bedrock of the administrative state. Presidents from both parties have respected this boundary, shaping these agencies slowly through appointments as terms expire, rather than through sudden mass purges. Donald Trump is asking the Supreme Court to overturn this 90-year-old precedent entirely. The arguments presented by the Department of Justice in this case are breathtaking in their scope. Solicitor General D. John Sauer appeared before the justices to argue that Article 2 of the Constitution grants the President absolute, unchecked control over the entire executive branch. The DOJ's position is that any law attempting to insulate an official from being fired by the President is, by definition, unconstitutional. They argue that these removal protections leave the President saddled with subordinate officers who can block the faithful execution of the laws. In layman's terms, the argument is that if the President wants something done, and a regulator says no, that violates our specific agency guidelines, the President should be able to fire that regulator on the spot. If the Supreme Court accepts this theory, it implies that independent agencies are basically illegal pockets of resistance that prevent the president from exercising total control. However, during the oral arguments, we saw something very interesting happen. The justices, including some who might be expected to favor executive power, began asking incredibly skeptical questions. They seemed deeply concerned about the practical chaos that would ensue if they agreed with the DOJ. They probed the Solicitor General on whether there would be any limits left on presidential power. They asked what would happen to the dozens of other agencies that are structured this way. This skepticism from the bench highlights the massive stakes involved. If the court rules in favor of Donald Trump, it affects far more than just the FTC. We are talking about a list of over 24 agencies. This includes the Federal Reserve, which manages the economy and interest rates, the Securities and Exchange Commission, which polices the stock market, the Federal Communications Commission, which regulates media and internet, and the National Labor Relations Board, which protects workers' rights. If the cause requirement is struck down, a president could theoretically fire the entire board of the Federal Reserve because they refused to lower interest rates before an election. He could fire the leadership of the SEC because they were investigating a political ally. The entire concept of neutral, expert-based governance would be replaced by a system of strict political loyalty. This brings us to the broader context of what is being described by critics as a purge strategy. The firing of Rebecca Kelly Slaughter is not an isolated incident. We have also seen the removal of members from the National Labor Relations Board, or NLRB, and the Merit Systems Protection Board, or MSPB. Let's take a moment to explain what the MSPB does, because it is vital to the federal workforce. The Merit Systems Protection Board acts as a shield for federal employees. It ensures that civil servants are hired and fired based on merit, how good they are at their job, rather than their political affiliation. By firing the leadership of the board that protects employees from political firing, the administration is effectively dismantling the safeguards of the civil service. A lower court, the D.C. Circuit, has already issued a split ruling in a related case involving the NLRB and MSPB, suggesting that because these officials exercise significant power, they should serve at the pleasure of the president. However, that ruling is under appeal. The Supreme Court's decision in Trump v. Slaughter will likely be the final word that settles all of these disputes. It will determine if these recent firings stand or if they were illegal acts that must be reversed. We must also look at the historical parallel here to understand the why behind the panic among constitutional scholars. Before 1883, the United States operated under what was known as the spoils system. When a new president won, they fired almost everyone and handed out government jobs to campaign donors, friends, and political supporters. Competence didn't matter. Loyalty did. This led to massive corruption and government incompetence. The civil service reforms, starting with the Pendleton Act of 1883, were designed to end the spoils system. They introduced the idea that government work should be a profession based on expertise. The independent agencies are an evolution of that reformist tradition. Critics argue that Donald Trump is attempting to revert the U.S. government back to the pre-1883 era, creating a modern patronage system where the only qualification for holding power is devotion to the president's agenda. In practical terms, the DOJ is arguing that the president feels saddled by anyone he cannot command. But the counterargument, which seemed to resonate with several justices, is that those saddles are actually the checks and balances required by a functioning democracy. The fear expressed during the hearing is that without these protections, the federal government ceases to serve the public interest and begins to serve only the personal and political interests of the occupant of the White House. While the slaughter case is the headline, we must also address a separate but related ruling that came down from the Supreme Court just recently. In a 6-3 decision, the court ruled to limit the power of federal judges to place nationwide holds, or injunctions, on government decisions. While this ruling was focused on the legal process regarding judicial power, it has immediate practical implications for birthright citizenship. The administration has made it clear they intend to limit birthright citizenship, the principle that anyone born on U.S. soil is a citizen. This policy was expected to be immediately blocked by lower courts. However, with this new 6-3 ruling limiting those judicial blocks, the path for Donald Trump to implement this policy through executive order becomes much smoother. Justice Barrett, writing for the majority in this procedural ruling, noted that the executive order on birthright citizenship would not take effect for 30 days after the opinion, giving a small window for legal maneuvering. However, the message is clear. The judicial brakes that usually slow down radical policy shifts are being loosened. For immigrants, visa holders, and undocumented residents, this creates an atmosphere of intense uncertainty. The legal assumption of citizenship that has existed for decades is now in doubt, and the lower courts may have fewer tools to intervene to protect the status quo. So, when we zoom out and look at the full picture, we see a two-pronged shift in federal power. On one hand, the Supreme Court has limited the ability of lower court judges to block presidential actions regarding issues like citizenship. On the other hand, the court is now deliberating whether to grant the president the power to fire independent regulators who were previously protected by law. If the Supreme Court sides with Donald Trump in the slaughter case, it will represent one of the most significant expansions of presidential authority in American history. It would signal the end of the independent agency as we know it. The FTC, intended to protect consumers from monopolies, would become an arm of the White House. The NLRB, intended to arbitrate labor disputes neutrally, would become a tool of political policy. The justices asked tough questions, and they appeared hesitant to overturn 90 years of precedent simply to grant one man absolute control. They wrestled with the reality that this would fundamentally reshape the government into a hierarchy of loyalty rather than a network of expertise. But as we know, questions during oral arguments do not always predict the final vote. The decision, expected in the coming months, will tell us what kind of government the United States will have for the next century. Will it remain a system where expert regulators act as a check on political power? Or will it transform into a system where the president has total, agonizing control over every lever of the federal machinery? The firing of Rebecca Kelly Slaughter was the spark, but the resulting fire could burn down the structural independence of the entire American administrative state.